The United States Supreme Court will hear Donald Trump's attempt to delay or end the trial scheduled by the Justice Department and Special Counsel Jack Smith for his January 6 conduct. By shorthand, you may have heard this called the immunity case. What we have new just within the last hour is the Supreme Court deciding to weigh in, to take the case, to delay the trial. As we will get into tonight, that's not something they have to do, but it's something they have the legal authority to do, and it's something they are doing. So the court is granting this cert, this review, late today. And they're giving a calendar, which we're going to get into because it has huge repercussions for the court, for the country, potentially for the election, and for whether or not prosecutors and our FBI and Justice Department can patrol efforts to overthrow American democracy, to stage coups. The court says it will take this case and hear the arguments the week of April 22nd. This means no matter what, we know something tonight we didn't know last night. The Jack Smith scheduled coup trial and his victories, because he's won not one but two basic hearings about whether or not presidents have immunity when they leave office. Both the trial judge and the appeals court unanimously said they don't. But having won those earlier scuffles on this immunity issue, his trial of former President Trump is now delayed, if not potentially mooted, until the election. I want to show you briefly the legal calendar we've made because there is still another trial scheduled. You may recall the confirmed trial you see in the center screen is that green arrow, the hush money trial scheduled for New York. It is a local criminal trial, but not as serious as what everyone had their eye on, the DOJ coup trial. What you see just above it to the right is now our updated information. The SCOTUS appeal will take place, as mentioned, in April. So we have in March a criminal trial on what is an older and lesser set of events. And then in April, a Supreme Court SCOTUS appeal of whether or not there ever will be a federal trial for what Donald Trump stands accused of, leading up to and including the day of January 6th. The issue here is that even if the court rejects Donald Trump's claims of endless permanent immunity, as many expect, this act of merely taking the case, depending on the calendar, could delay it close to the election, as some of our legal experts were discussing moments ago, or potentially past it. So what happens next? I want to bring in the top guest we could have for this exact kind of federal question. Andrew Weissmann is a former special counsel in the Mueller probe. He's also served as FBI general counsel and as a federal prosecutor. Welcome, Andrew. There's so much here, and I want to get into it with you. Our experts were making sense of it with Nicole moments ago. I want to say one thing about that and then get into what this means and says. But in the spirit of transparency and keeping it real with the viewers, as I always do, I'll tell them that I was both reading this, listening to you and others, talk to Nicole, and it struck me, and it may have struck some viewers, that there was a tension between many lawyers saying, well, here's how it works, and here's the calendar, and here's what still could happen. And Nicole, who is as seasoned and wise a Washington Power player and observer as anyone I've gotten to work with, saying, sure, but bottom line, isn't this the Supreme Court rewarding the delay tactics and really legitimizing and affirming a schedule that ultimately could mean Donald Trump doesn't face trial by November and thus got a kind of immunity in practice, if not in precedent?
I would say I was saying the same thing, which is what I am very concerned about is a Supreme Court where there are at least 5 votes that say there is no presidential immunity, but they take so long in making that decision that they are giving de facto immunity, so that they write some opinion for the ages with beautiful language about the presidency is not above the law, and this is what the role of the Supreme Court is, et cetera, et cetera. But the effect of that decision is with respect to the one and only instance of a president, alleged to have committed criminal acts to.
We may have lost a little bit of Andrew's audio, which I know they were working on previously. Andrew, I was telling the viewers, I think they may have seen what I saw, which we lost a little bit. Just make your final 3 sentences again, please.
Sure, that I'm concerned about them essentially giving a de facto immunity, that they say there is no immunity, but because your point is, and Nicole was making, the delay itself de facto gives immunity to this former president. And that, I think, really would undermine the system of law. It's the point Nicole was making about, does our system of law, can it really hold somebody who plays and games the system? And so that's why I do think the point you're making, a lot of this comes down to math, calculating timing, and what can Jack Smith do at this point? Because remember, there were 88 days. You said it. So let me.
Yeah. You said it. So I'm only slowing you down to say, let's get into that calendar math. I have all the trials up on the screen because we've been updating this for viewers, and some of them, the ones in yellow, aren't even currently likely to happen soon. The green is New York next month. That is on, but the red SCOTUS appeal, now set for April, is the big headline tonight. And so, Andrew, I'd love to go through this with you, both the fast version and the slow. And here we are in the 6 o'clock hour on the East Coast. This news broke about an hour ago. People may just be joining us. The headline is the Supreme Court is taking Jack Smith's Jan 6 trial of Donald Trump. So they are going to review it. Donald Trump has lost 2 rounds of arguing that he should have permanent immunity. I've reminded viewers, you don't need law school. If you just remember that guy, Richard Nixon, he was president and then he took a pardon because he, as a former president and then President Ford, all agreed, of course, he could be prosecuted. He needed the pardon. Trump has lost his ahistorical claims here on 2 court battles. And so now the Supreme Court's going to hear what is thus far a losing argument. So I want you to walk us through the fast and slow version of what could happen next.
Sure. The worst case scenario is that the court takes its time. It says it's going to hear the case the week of April 22nd. It takes its time to issue its decision. It presumably would issue it by the end of the term, which is the end of June. It obviously could decide at that point that the president is immune, or there should be fact-finding. I mean, things that would not even resolve the issue. But let's take a sort of maybe best-case scenario, is they say there are at least 5 justices that say that there's no presidential immunity. You have to then consider the time frame. Once they give a green light to Judge Chutkan, she had a lot of pretrial work she needed to do. The government has said that the trial will take 3 months. If you add those factors in, the 88 days that she could give the defense to prepare, the fact that the trial could go 3 months, you're talking about a time frame where you are really pushing up against the general election. Now, having said that, Jack Smith has some things that he can do. He could make an argument to the judge that the 88 days should be shortened, that time frame that she had given before isn't needed. It was too generous. They could also shorten their trial. They could say that we are not going to do a 3-month trial.
I'm only jumping in because now it's feeling really tactical to me. And Andrew, if it's tactical for me, how do other people feel? Because these are 2 legal nerds. So I'm going to say, putting tactics a little bit aside, what is the latest you think they could reasonably start this trial?
I think if it doesn't start by sometime in July, I think it is really hard to see the judge saying that they're going to go forward and have him. I mean, at some point, there is going to be pressure on the district judge to say, am I going to have the leading candidate for one of the parties on trial and not being able to, has to attend to a trial and should be running for office? At some point, that tension, I think, is going to be something that weighs on her mind.
And I want to be clear with viewers, that is a reasonable consideration, a practical or prudential consideration. Plus, I guess it's partly policy if you want to get into the DOJ rules about how close you do things to the election. But that's a reasonable consideration. We're not necessarily second-guessing a judge having to think that through. But we are asking why the Supreme Court has acted to enter into this fairly narrow question that's been resolved. It's not been a big question prior. That's, of course, Supreme Court can do what it wants, but the lower courts have said, no, you don't have permanent immunity. And so you're saying it's got to start July-ish. This is a perfect introduction to your partner in law, Neil Katyal, one of the foremost Supreme Court experts in the country, who has hustled to join us here. Welcome, Neil. I'm sure you've heard some of this, and we could get your response on the trial timeline, but I also want to reset the deck and read to you what it says, and you'll give us your big picture as well. The special counsel's request, the Supreme Court says, to treat the stay as a petition is granted. The petition is granted to this question: whether and to what extent a former president enjoys, quote, presidential immunity from criminal prosecution for conduct alleged to involve official acts during his tenure in office. And the court takes that question on this timeline. Neil, for our viewers, please give us your thought on this big Supreme Court news tonight.
Yeah, so Ari, in general, I'm such a believer in the United States Supreme Court in general as an institution. I was there this morning arguing a different case with my partner, and I have to say I'm gravely concerned about what has happened today. The idea that the U.S. Supreme Court could potentially delay this trial until after an election when the American people deserve to know what Donald Trump did on January 6th and the different actions he took, and to have a jury of his peers decide it. I'm very concerned that that may now not happen. What the Supreme Court has done here is to what they call expedite it. They certainly could have expedited it more, but to hear this case on April 22nd. And I think now two things should be happening. One is the court and everyone needs to hear from the American public about how the court needs to decide this case quickly after April 22nd. This is not a hard case, sorry. You and I have talked about this before. Andrew's made the point. Donald Trump's arguments here are, I think the technical legal word is absurd, and the court shouldn't take much time in deciding it.
Ellie, you know the saying, it's time to put away childish things. 25 minutes into the hour, it might be time to put away the legalistic things, which is part of our job, and we've reported it out. And I explained what the cert is, and I read it, and we talked about the calendar. But we invited you on tonight as someone who knows the law but is not necessarily limited by some of the, shall we say, BS. And so I was curious what you think the Supreme Court is actually doing, not what it's saying it's doing, not what might feature elegant prose at the end of the day in the ruling, but what do you think it's actually doing?
They're trying to make Trump win. The whole point of this ruling is for Trump to win. Ari, remember how, let's say, all of 2022, I came on your program and I screamed and I tore my hair out over how Merrick Garland was moving too slowly to hold Trump accountable before the next election? This is why, because you have to understand what the Supreme Court is really about. I know you like to give your viewers context, so have this on for some context about what the Supreme Court is really up to. Trump was kicked off of the Colorado ballot, right? And around December 20th last year, the Supreme Court spooled up that case and heard that hearing within 45 days on February 8th, all right? Trump was appealed his immunity, Judge Chutkan's immunity ruling, also in the middle of December. Andrew Weissman just pointed out, Jack Smith asked the Supreme Court to hear the case on December 14th. By the time we get to April 22nd, it will be 130 days since they were asked to hear the appeal. So it's 45 days when a ruling could hurt Trump, but 130 days when the delay can help Trump. That is the essence of this Supreme Court. And every single Democrat who is not on board for expanding the Supreme Court and reducing the power of these Republican theocrats in robes is in some way complicit in today's failure.
Excellent numerical, factual context. Michael, your thoughts?
I want to pick up on something that both Neil and Andrew pointed out, and it really goes to the heart of what my friend Ellie just laid out, and that is Donald Trump has basically said, as president, you can't come after me. Now that I'm done with my presidency, you can't come after me. And the court is now in the position to say, yeah, let's sort of stretch this out a little bit longer. And the reason why the timeline is very problematic is the court knows that election voting begins immediately after Labor Day, in some states as early as the last 2 weeks of August. So the idea that you're going to delay even addressing this issue possibly to the end of the term, June, tells you there is no way in hell you're going to get this case before the process of being adjudicated before then, before this election is over. And so the idea then falls back on the lower court judge, all right, in this case, Judge Chutkan, to basically chuck it until after the election, because there's no way she is going to be in a position to have Donald Trump hauled into court to sit during trial in the middle of a presidential campaign in September, October.
And so let me take that alley-oop logically to Ellie, which is these are smart lawyers who've become judges, who understand all this. And we are not talking about some random, debatable offense that occurred while someone was in office. That does happen, right? We are talking about whether there will be any adjudication of an effort to overthrow the election results before that person comes back into power, Ellie.
Yeah, and they don't want that adjudication to happen. Remember, we haven't talked about this, but remember, even while granting the case, even while granting cert, the Supreme Court didn't have to grant the stay. They could have allowed Chutkan to continue with her trial preparation and her trial calendar while they were deliberating the issue, right? They didn't have to grant the stay. That was a choice. Just like it was a choice to wait 130 days. Just like it's a choice when they finally hear the case for how long it's going to take them to release their opinion. All of these choices, as you say, are to help Trump explicitly. Because cui bono, as Cicero would say, cui bono, who benefits? Who benefits from this delay? Americans, American democracy, knowing who is allowed to run and who we can vote for? No. The only person who benefits from the Supreme Court's slow walking of this case is Donald Trump himself personally, because it gives him a chance to win re-election before accountability comes reckoning upon his head. And that is what the Supreme Court is complicit in doing. And I think they might as well call themselves on his defense team. It's not like they're going to get paid anyway. They might as well just put themselves on his defense team's roster.